Hello, and welcome to the Senior Care Channel. My name is George Roach. I am an elder law and estate planning attorney with over 35 years experience in this field. Today's topic, we're going to take it to another level. In previous shows, we've talked about Medicaid eligibility and how to plan to pay for that long-term care. Today's program, we're going to focus in on the use of trusts and trust planning to protect assets in a long-term care situation, which I often say is really the gold standard as far as planning. And when we talk about trusts, it creates a lot of confusion in people's minds. It's things, certain times I've seen senior citizens, they don't know what it is. What I want to do is take the mystery out of it today for you and break it down so you can wrap your mind around it and have a concept of what a trust really is and what it does for you. Now, believe it or not, the concept of trusts have been around historically since the Egyptians. You just look at the word itself, trust. When you trust somebody, what do? You are comfortable with the fact that these people the people you trust, they will follow your wishes, they will listen to your request. Many times when we talked in a previous program about documents, we talked about the will, the durable power of attorney, healthcare proxy, and living will, the four little documents that each and every one of us should have. Well, believe it or not, those documents are based on trust. The durable power of attorney, you're designating somebody, an agent, a person that you trust, you are comfortable with, to handle your legal and financial affairs. If something should happen to you, you have somebody in the on-deck circle to come into this ball game and manage your entire nest egg, what you've saved up over the course of your lifetime. Very, very important role as far as the issue of trust goes. So an agent in a durable power of attorney better be somebody that you trust and who can follow your wishes and will not dissipate or spend your nest egg on things you wouldn't want. Very important. That's the concept of trust. Same with the healthcare proxy. Again, the person you name as your healthcare proxy is your agent, somebody you trust who will make your medical decisions, hopefully, just like you would make them, which means you're choosing somebody who can follow your wishes. And it presumes that there's communication between you as the principal and your agent, the healthcare proxy. You have to tell these people how you feel about medical issues, especially about end-of-life treatment. That's critical. It's important. It's important to you because one of the reasons we call these documents advanced directives is because when you need them, you are no longer in a position to communicate your wishes, which is why the people you choose are very, very important, and you must have trust and faith in these people. So as we get the concept of trust going, all right, that concept follows over into legal documents. And basically when people say trusts, all right, what are trusts? Basically they're contracts. They're contracts between you and the person you choose who agrees to hold property on your behalf for you until such time as events happen, whether it's death or a nursing home. All right? We use these documents, these trusts, to protect property. Think of them in your mind's eye as a lockbox. All right? That's exactly what you're doing when you're creating a trust. You're creating a legal lockbox. It has walls, it has a key, it has people who keep control of the box, and you direct how the property is going to go, either after you've gone or if you go into a nursing home. So that's the concept. Think of it as a box, a trust. Now, there are many different types of trusts. Basically, we'll start with two categories. There are trusts you can create after you die, and there are trusts you can create while you are alive. Those are the two basic distinctions. After you die, while you are alive. Now, we in the legal field, we give the trusts that you create after you die, we give them a fancy name. We call them testamentary trusts. Why? Because they're created in your will. That's what happens. They're created in your will. And after you die, that's when the trust goes into effect. The other trusts that you create while you are alive, we call them living trusts, solely by virtue of the fact that you are alive and well and competent when they are created. Much like the distinction I made in a previous program between community Medicaid and nursing home Medicaid. Well, why did we call it community Medicaid? Because you were not in a nursing home, you were in the community, living either independently or with somebody else. If you're in a nursing home, different type of facility and different set of Medicaid rules, vastly different from the community Medicaid rules. Well, here we have testamentary trust after you pass away, or we have living trust, which you create while you're alive. And you can create pretty much the same type of trust in either camp, either in your will or while you are alive. Now, the use of trusts, okay, as far as estate planning goes, it has a tendency to be a little bit more sophisticated as to what you're doing, so you really have to grasp what's going on conceptually, all right, what you're doing with your property. And secondly, you have to trust the people that you put in those positions. We call them trustees. So I can create trusts in my will, and I can create trusts while I'm alive. Now, basic example. Trust you create while after you're gone, in your will. Testamentary trust, as we call them. Most basic is the fact that, let's say you have children under 18 years of age. Well, the law says that children under 18 years of age really can't inherit property. They don't have the capacity to take that property, use it wisely, spend it, save it, whatever they're going to do with it, all right, because they're minors. So one of the standard provisions we put in a last will is that if any children under 18 years of age inherit property from you, and they're not old enough, we're going to hold it for them. We're going to hold it in trust for them. The executor is the person you name in your will to run the show after you're gone, protect the property, distribute it according to my wishes. That executor has the power to hold the property for that child's benefit. And sometimes they can, if the child needs it after they turn 18 and needs it for college, tuition, a legitimate good purpose, the executor will pay for that. And many times, if the child is going to inherit property outright, once they turn 18, sometimes you actually have the right to put limits on the property. For example, if they don't use it to go to college, I don't want them to get it when they're 18. Maybe I want them to get half of it when they're 21. All right, and see how they spend it. All right. Do you find out they don't spend it wisely? That's why you're protecting the rest of it. You're saying, all right, then they get maybe half of what's left by the time they're 25. And if they dissipate that, then at least they get the rest of it by the time they're 30 or 35 years old. Sometimes they put restrictions on the property for children, solely for that purpose. But if they're going to go to college and go to graduate school or law school or any other professional school, the executor has the discretion and authority to pay for that tuition because the child is doing something good with it. Many times, people have a disabled child. All right, child, for whatever reason, is disabled, can't function, has a limited mental capacity. Well, what were your choices in the past? In the past, your choices were, I could leave that child his proportionate share of my estate, and if that child was receiving government benefits like Medicaid or SSI, Supplemental Security Income, and they inherited property from me, they lost it. They were over the resource level, their government benefits were terminated, and the property was spent and dissipated. The only other choice I had was to disinherit that child. So, for example, if I had 3 children and one of them was disabled, I could, in my will, I can disinherit anybody I like except my spouse. I can cut out the disabled child, leave his or her share to the brothers and sisters, and hope that they will use it for that child's benefit. But they were under no legal obligation to do so. And along the way, people said there's got to be a better solution to this. We have to have something for disabled children, all right, regardless of their age. And the answer became what we call a special needs trust. A special needs trust. And essentially, or what they call a supplemental needs trust. The names are interchangeable. Special needs, supplemental needs. If the child who was disabled is living in a group home, getting Medicaid, all right, paying for their medical, and they get a limited amount of money per month under the SSI program, I don't want them inheriting their share outright. So what I do is, in my will, I create a supplemental needs trust. If I have 3 children, that child's 1/3 share will go into the supplemental needs trust, which I create after I die. The 1/3 share goes in there. The surviving, his or her siblings, are usually the trustees, but I can name anybody I choose, all right, the people who are going to distribute that property. And the property in a special needs trust, or supplemental needs trust, I use the words interchangeably, is used to supplement their lifestyle, not supplant any government benefits that they would be receiving. We don't want to see them lose their Medicaid. We don't want to see them lose their SSI. We don't want to see them lose the group home. We want to keep those benefits, but we want to enhance the quality of their life. And for example, if you have a child who maybe has the mental capacity of a 10 to 12-year-old, all right, even though they're 47, 50 years old, all right, that child would like to go on vacation, would like to go to Disneyland. They can't travel by themselves. They can't buy an airline ticket. They can't rent a hotel room. They can't rent a car. Somebody has to do it for them. So the money that was set aside in the special needs trust, that's what it's used for. Many times you'll have a child who is handicapped and wheelchair bound. And that child needs transportation. Well, we need a customized van so we can get the wheelchair up on a ramp into the van. We can customize the van with hand controls, and that money can be used, special needs trust money can be used for that purpose, to enhance the quality of their life. And that's really what most parents want for their disabled children. It's a big concern among older people is who is going to care for that disabled child after I pass away. The parents have raised that child. It's a terrible burden to put on the shoulders of the brothers and sisters. So to answer that need, that's where the special needs trust came about. And now it's commonly accepted, and you can create that special needs trust in your will. Now, you can also create a special needs trust while you're alive. And that brings us to the other side of the table. I said there were testamentary trusts that we create in our will. There are also trusts we create while we are alive. And we call those living trusts, solely for that purpose, that we created it while we're alive. You can create a special needs trust while you're alive. Now, basically, living trusts fall into 2 categories. Right? They are either revocable, where you can revoke them, or they are irrevocable. Revocable or irrevocable. Now, the most common one that most people read about in the paper is the revocable trust. Why do people create revocable trusts? People create revocable trusts for a couple of different reasons. The main one being they want to avoid probate. They want to avoid that situation where assets pass under a will. You have to file the will with the court, start the probate process. It can get lengthy, it can get expensive, depending on the type of estate and the amount of property you've left behind. So we want to avoid that. One of the ways to avoid probate is simply create a revocable trust. One of the rules, you can be, here in the state of New York, you can be the trustee of your own revocable trust, which means you manage your own property. The trustee is the person who runs the show and manages the property. Now, you can be the trustee of your own revocable trust. The property is transferred to the revocable trust, and upon your death, the trust itself, the language in the trust, says who gets the property after you're gone. All right? There's no probate, no will. All you have to do is the trustee simply distributes the property according to the terms of the trust. And basically that's it. All right? One of the reasons you create a revocable trust, as I said, is to avoid probate. Another important reason you create a revocable trust is if you have or own property in another state. Now, this is America. People own property in New York and they have a condo in Florida. They own property in New York and they have a timeshare in Disney. Wherever it happens to be. A golf condo in Palm Springs, California, vacation home in Maine, you name it. Ski chalet in Vermont. Well, if you have property in another state, you don't want to go through what we call ancillary probate. What does that mean? You died domiciled here in New York, but you own property out of state. Well, you got to start your New York State estate. You got to start your New York estate proceeding. Once the executor's been appointed, that executor has to get appointed in another state if you have property. Or if you have property in multiple states, it's called ancillary probate. Your executor has to get approved in all these different states. It's time consuming and it's expensive. So how do we avoid that situation? If I own property in another state, I create a revocable trust and put the property into that revocable trust, into that box that I talked about. The deed from the property goes from me right into the trust in the name of the trustees. This way, when I pass away, I don't have ancillary probate. My trustees simply deed out the property to whomever I choose. And I avoid an ancillary probate situation. I avoid probate and I avoid an ancillary probate. Another reason people create revocable trust is to avoid litigation. Each and every one of us knows our own children. Whether or not they're at each other's throats all the time, you know after you pass away, if you haven't put your ducks in a row, put your affairs in order, these kids are going to wind up suing one another. The way we avoid that, very simply, is to create a revocable trust. Because trusts are very difficult to challenge in court. If you leave a will, when people leave a will and pass away and that will gets probated, you're almost inviting a challenge. You have to give notice to everybody who takes under the will, we call them distributees, and say, look, if you have any objection, come on forward. Let us know what's wrong with this will. All right? And a lot of times, a lot of emotional baggage gets vented in a probate proceeding. You don't have that with a trust. It is very, very difficult to challenge a trust. So, to avoid probate, to avoid ancillary probate, property in another state, and avoid litigation among heirs, you create a revocable trust. Now, what you have to understand, as far as long-term care goes in our society, these revocable trusts are only good, really, if you pass away. They don't do anything to protect that property in a long-term care situation, either at home or, God forbid, you need a nursing home on a permanent basis. The rule of thumb is very simple. All right? If you can get your hands on the property by revoking the trust, that is exactly what the Social Services Department is going to force you to do. They're going to, if you need long-term care at home or in a nursing home, they're going to say your property's in a revocable trust, which you can revoke and get the property back. We're going to force you to revoke it if you ever expect to get Medicaid. And that's what happens. The revocable trust, which you thought was going to be the be-all and end-all of your problems because you never anticipated needing long-term care, you thought you were just going to die in your sleep. That That didn't happen. Now you need long-term care. I wind up revoking my trust, getting the property back, goes back in my name, just like I never did any planning at all. So the question becomes, if a revocable trust will not protect my property in a long-term care situation, what kind of trust does? And the answer is an irrevocable trust, or irrevocable trust, depending on which extent you put the syllable. Irrevocable. Now that scares a lot of people. It shouldn't, because I want to take some of the mystery out of it for you. As I said, the irrevocable trust is the gold standard as far as estate planning goes. It protects your property and avoids all the probate, right? Same as the revocable trust did. And in addition, it protects your property in a long-term care situation. Right? And how does it work? As I said earlier, think of the irrevocable trust in your mind's eye as a lockbox that you created. All right? It's got walls, and what are we going to put into this box? Well, I want to protect my property, my nest egg, so I'm going to take my assets, whatever I choose, and I'm going to put those assets in that box and lock them up. All right? Let's start with probably the largest asset most people own, my house. I want to protect my house. God forbid I need long-term care. All right, put the house in the box. Suppose I have some money. Bank accounts, stocks and bonds, investments, I can put those in the box. Each client individually is different, has a different financial profile. You don't put everything you own in that box. You're going to leave some out as a cushion. You always make sure of that. You don't want to pauperize yourself, but you want to take a look at your financial profile and see what assets I can afford to protect. Now, obviously, if you put a house in the trust, your residence that you live in, it doesn't generate any income to you. Okay. Suppose I put some money in the trust in the form of bank accounts, stocks and bonds, investments. Well, prior to being in the trust, in the irrevocable trust, I was getting the income from those investments, the dividend, the interest, such as it is, but I was getting it. I was able to live on it in addition to my Social Security, my pension, and my interest income, my dividend income. Great. You don't lose that. Once those assets are in the trust, you continue to get all the income from those investments that are in the trust. They're just simply retitled, we call them. The bank, instead of the bank account being in your name, paying you interest, the bank account's in the trust name, paying you interest. That's all that happens. You retitle the asset. I'm getting the income, and of course, the question comes up from a tax perspective, who pays the taxes? Well, you don't want the trust paying the taxes because the trust has a very high tax rate. So because you're getting the income from the trust, you pay the taxes at your current tax rate. That's all that happens. Nothing changes. You're still paying the tax on the income you're getting from the trust at your personal tax rate. Now, you, since it's your trust, you cannot be, or if it's a spouse, you and your wife, cannot be the trustees of your own irrevocable trust. You have to give up that control. You can be the trustee of your own revocable trust, but you cannot be the trustee of an irrevocable trust. So, who do you choose as your trustee? Somebody you trust. Going back to the derivation of the word, somebody who will follow your wishes, somebody who will protect that property, somebody who has your best interest at heart. And many times it's children. All right, it's you have trusted children. If you have more than one, you know your kids, and you know which child has the best financial head on his or her shoulders. Very important to choose somebody with a little financial savvy as your trustee. Somebody who doesn't have debt problems or bankruptcies or is going to be involved in a divorce type situation. You have to consider all those types of circumstances. It's very important who you put in the driver's seat as your trustee. They're holding the keys to this trust. Now, in addition to being trustees, children are also the beneficiaries of that trust. They're the ones, if you pass away, the trust is going to pass the property to them with no probate. All right? So you avoid a probate situation with an irrevocable trust. Very important. Now, once the property is in the trust, as we said in a previous program, if you're applying for long-term care, there was community Medicaid with no transfer rules, and there was nursing home Medicaid with a 5-year look back. So now my house and some property is in an irrevocable trust. I put the property in the trust, it's there. For community Medicaid purposes, I am eligible for Medicaid. Why? They cannot, since there are no transfer rules for community Medicaid, they cannot penalize me for transferring my property to the irrevocable trust. So I am immediately eligible for community Medicaid. They can't use the property I put into the trust to deny me Medicaid. However, once the property is in that trust, I do in fact start a 5-year look-back period. That property has to be in the trust for a period of 5 years. Once the 5 years is up from the day I put that property in the trust, I am eligible for nursing home Medicaid. I've sat out the 5-year period. All right? And sometimes that's a real if. You know, sometimes people, you roll a dice and you see if you can get 5 years down the road. So when you create the irrevocable trust, you simply have to stay out of the nursing home for 5 years. All right? Now, suppose I want some of the property that's in that trust. Well, for the first 5 years, you really can't touch it. Okay? Which means if you start creating this trust when you're 65, 70 years old, 5 years is a drop in the bucket. Once the 5 years is up, these irrevocable trusts have a back door. Right? Let's say the property's in there for a period of 5 years. It is now protected. I am still healthy, and I want to take one last cruise. I want the one last hurrah. All right? So how do I get money out of the trust? Very simply. I tell my trustees, my children, I want you to take $30,000 out of the trust, and as beneficiaries, because many times they're the same people, I want you guys to buy me a ticket on the Queen Mary, all right, for my trip around the world. The trustee does not give the money to me. You can't give it back to me, but they can buy me things like a vacation, a new roof on my house, a new car. They can take the money out of the trust and give it to themselves. Sometimes we call that an advance against inheritance. That's what it is. They take it out the back door, they give it to themselves, but they buy me something with it. And as long as I don't get the actual money back, I'm good to go. Now, the question becomes, what happens if these trustees change their mind? And they don't want to take the money out the back door, because if they spend it on a trip for me, that's less money that they're going to inherit. Well, that's why you have to choose your trustees carefully. Number one, somebody who will follow your wishes. And number two, you still have control. Because with these irrevocable trusts comes a little thing we call the hammer. All right? Legally, it is called a limited power of appointment. Limited power of appointment. You won't remember that, but you'll remember the hammer. And what that means is the limited power of appointment, you retain the ability to change the beneficiaries, who inherits the property in the trust. So really, it keeps the kids interested. It keeps them sending Mother's Day cards and Father's Day cards and birthday cards and holiday cards. They keep sending that stuff in because they don't want to lose their inheritance. If somebody doesn't want to take that property out the back door and make it available to me, then I am simply going to lower the hammer. I am going to exercise my limited power of appointment, and that child's share simply went to the Salvation Army, went to another sibling. All right? I have control over what they inherit. So by choosing your trustees carefully and with the limited power of appointment, you pretty much have control over those assets. And as I said, you give up some control, you keep some control, you're still getting the income, you avoid probate, and after 5 years you protected those assets in a long-term care situation. All right, you're immediately eligible for Medicaid for home care. Once the 5 years is up, then the property is protected for nursing home type situations. And that's why we call them the gold standard, because it's sort of having your cake and eating it too. A couple of other types of trusts that we create while we're alive. I talked about disabled children before. You can create a special needs or a supplemental needs trust for a disabled child while they are alive. Now, there's a distinction here. There are third-party special needs trusts, and there are first-party special needs trusts. If your child was in a horrible accident, the result of which they became disabled, and they started a lawsuit and they got their own money, all right? Anytime you set up a special needs trust with your own money, that's called a first party special needs trust. And in that first party special needs trust, there has to be a provision to pay back Medicaid. It's called a payback trust. First party trusts are called payback trusts. You have to pay back Medicaid with any money that's left in the trust after you pass away. All right? Medicaid is paid for your medical needs. The money in there should have been used to supplement your needs. Big screen TV, recliner, trip to Disney World. We went through that earlier. Okay? The third party special needs trusts, one that a parent would leave property to a child who's disabled, that's called a third party special needs trust, and there is no payback provision. All right? None. You don't have to pay back Medicaid from a third party special needs trust. If there's any property left in that trust after the disabled person passes away, the trust can provide that it gets paid to any surviving heirs or their issue, the siblings of the disabled person, the brothers or sisters or their kids. They can get that property. You don't have to pay back Medicaid in a third-party trust situation. Last little trust that we're going to talk about today, we talked about minority trusts where trustee can hold property for children who are not 18. We talked about special needs trusts. Many times, if you have done very well and you are heavily insured, you have a big life insurance policy, all right? Life insurance can put you over the limit for estate tax purposes. And here in New York, the estate tax limit here in New York is $1 million. All right, anything over $1 million gets taxed by the state of New York. So if you have $1 million in property and a $1 million insurance policy and you die, you now have a $2 million estate. Okay, the first million passes tax-free. The state of New York gets to tax you on the next million. It's about $99,000, all right? So the question becomes, is there a way I can get that insurance policy out of my estate so it's not taxed to me for estate tax purposes? And the answer is yes. And the vehicle we use, the trust, the type of trust we use to get that out is called an irrevocable life insurance trust. Irrevocable life insurance trust, sometimes referred to as an ILIT, I-L-I-T, irrevocable life insurance trust, the sole purpose of which is to get that large insurance policy out of your estate so it's not there for estate tax purposes. All right? And those are some of the things that we should be considering for estate planning purposes that we try to broach with the client when he or she, or both as a spouse situation, come into the office and show them the benefits of trust planning, especially that irrevocable trust. And one last little word, although we call them irrevocable trusts, let's say I fund it, I put all my stuff in the lockbox, all right, and I'm waiting out the 5 years, and something happens, I come up short, and I need a nursing home within the 5 years, then we simply have to undo the trust. We can bust that trust. Although it is called an irrevocable trust, if everybody who is beneficially interested in that trust are all adults and all consent, we can revoke that trust and get the property back, and then we can do another form of planning called the loan gift use of a promissory note, which we'll talk about in a later program. Thank you all. Have a good day. Age well. Thank you.